Who's the judge?
This is a public service.
You what?
Yeah, sit here. That way you're with me. We're going to get a chance to speak. Alright.
Where's Rachel?
Rachel? Rachel's sitting over there. I'll have a couple other people. Let me show you this though. Where'd he go? Right there. Oh, we have pen. Okay. I'll shop list. See? And I'm gonna tell you right now, this is what I didn't work on over this one. This one says her name on it right now. Her name Brown. I know. So I'm just gonna include it. Look at this. There it is. Oh, that's it.
Ladies and gentlemen, we have to have all participants seated, so if there's more someone, we need to.
You already filed the motion that you want to represent yourself. You filed that one, didn't you?
That's all right here.
You didn't
I served.
You didn't file downstairs?
No, they wouldn't. I thought I'd do it here in the court.
I'll ask.
Let's go on the record. Senator Zone versus Lane Jeffrey Myers, CR 2025-1060.
Rachel Stiles for the state. Your Honor, the victim is present.
This is William Parvin. I've been appointed to represent Mr. Myers. However, Mr. Myers would like to file a motion to represent himself. He's not sure exactly where to file that. If he can file in this court today or if he has to go downstairs.
Okay, good afternoon, Mr. Myers.
Good afternoon, ma'am.
This is a time set for your arraignment. We're going to proceed with your arraignment first, and then I'll talk to you about your motion. So is your true name Lane Jeffrey Myers?
You want me to sit down?
You can still.
You can be seated.
Yes, ma'am.
Okay. On the document there in front of you that your attorney has is the criminal charges filed against you. We are going to enter pleas of not guilty on your behalf. I am going to appoint OPAC attorney William Parvin to represent you for now. I'm going to assess $400 in attorney's fees. Your next court date is your case management conference, April 15th at 9 a.m. And then your pretrial conference is set May 16th at 9 a.m. Those are both in front of Judge Doug Metcalf, Division 16. You are ordered to appear at both of those hearings. Failure to do so can result in a warrant being issued for your arrest and a trial going forward in your absence. If you cannot be convicted, if you are convicted at that trial and cannot be sentenced within 90 days, you could lose your right to a direct appeal. And so, Mr. Myers, because I am not your trial judge, I'm going to ask you to file any motions that you have with your trial judge, which is Doug Metcalf, Division 16. I am also going to set a status conference next week in his division for your motion to proceed pro se. So
Thank you.
Be, March 20th.
After I file it, right?
March 20th at 1:30 p.m. in Division 16, and I'll write that on your paperwork here.
Thank you. Do I need to file it ahead of time or bring it with me there?
I'll let you talk to your attorney
All
about
right,
that.
thank you.
I think you can still file on the second floor of criminal cases. I use the online system, but I don't think you're set up for that.
No.
So go to the second floor and file everything and tell them where it needs to go,
Okay.
Judge.
All right, yep.
And you've already served copies, you told me.
Yep, on to Rachel.
Okay.
And then also give one copy to the chambers of Judge Mickliffe. They'll talk on the first floor how to do that.
Okay, okay.
By the way, there
Status
is.
conference regarding your petition to proceed pro se is March 20th at 1:30 p.m. and that is in Division 16. And then we also need to set conditions of release. Before we talk about that, Mr. Myers, you are ordered to report for fingerprinting and photograph on the 7th floor. You can do that before your first case management, or you can do that today.
7th floor?
7th floor. Does the state wish to be heard regarding the release?
Yes, Your Honor. Your Honor, the state is asking for a $25,000 bond and pretrial services release if that is posted. We're also asking for numerous conditions of any release. And I'm going to go through under Rule 7.2 of the Arizona rules that the release conditions, somebody is to be released on recognizance unless the court determines additional conditions are reasonably necessary to assure the defendant's appearance or to protect the victim, any other person, or the community from risk of harm by the defendant. And so we are asking for additional conditions. In this case, we're asking for no contact with the victim to protect her from physical harm, harassment, intimidation, or abuse. The court can also order additional conditions, including to protect another person or the community from risk of harm from the defendant. We believe that a non-monetary condition is not sufficient, so we're also asking for the monetary condition of the $25,000 bond. That's both for the reason that Mr. Myers is facing mandatory prison time if he's convicted of these offenses. He does have prior felony convictions that, while older, will make him prison mandatory. Even on the first felony offense and each subsequent felony offense, he faces mandatory prison time. These are also offenses that can be stacked, so he's facing a large amount of time. Also, he has had an injunction against harassment on him already, and so he's been court-ordered not to have contact with this victim. Yet, in spite of that, he has continued to have contact with her, reach out to her, ask for third parties to reach out to her. He has been posting about this case. He has been bringing attention to her, which has been subjecting her to harassment and intimidation. Mr. Myers himself, even after receiving the summons in this case, reached out again through an email he sent to the victim in this case. He again was online talking about this case, drawing attention on that post. That the posting was done by a third party, but he did participate in that post and was on that post. In that post, it posted again the victim's email address. It was asking for people to reach out to her. Her husband is also subject to that. And so we are asking for these release conditions of not just non-monetary conditions, but monetary. As far as the non-monetary conditions, we are asking for him to not possess any firearms. And most recently, we talked about wanting to get a firearm. Given the safety risk in this case, we are concerned if he were to get a firearm. We're asking again that for the no contact with the victim. We're asking for no contact with the victim's family, including no contact through any third party. We're asking for him not to be able to access the internet. He has been actively using the internet as a way to harm this victim, to harm other people, to intimidate any potential witnesses, to intimidate judges, to intimidate prosecutors. He has been posting, asking for people to go to people's homes and to go to their workplaces and to reach out to them. So I believe any further access he has to the internet will put people at harm. He can go, even if he represents himself, to the law library and be able to access what he needs to be able to do legal research. We would ask, if the court's not willing to just do no access to the internet, that he not be allowed on social media or to request third parties to post anything on social media regarding this case. We are asking that he not have any contact with anyone at the U of A School of Law, that anybody he contacts at that place of employment for a victim, he has been going to her place of employment and reaching out to those people and talking to them. It's part of an intimidation strategy. The people there are feeling uncomfortable and unsafe because of his targeting of those, and we would ask also for that to be that no third third person or third party can do that on his behalf either. We're asking again for him not to have any contact with the city prosecutor's office regarding Matthew Walker, or for him to go through a third party, because again, he's been targeting Matthew Walker, who's the spouse of the victim, and been targeting his office. Obviously, if he has a legitimate purpose outside of just asking people to reach out to Matthew Walker, that would be separate, but to not have any contact with him. And we're also asking that he not be able to disseminate any of the disclosure in this case. Mr. Myers did contact me and sent me an email where he indicated that was exactly what he wanted to do, wanted to stop the disclosure in this case, is he wanted to disseminate it on the internet so that everybody could look at it, which again would cause further harassment and intimidation of the victim. It also will put any potential witnesses at risk, and it's going to create problems for if this case were to proceed to trial of getting a fair jury pool who hasn't seen, who currently wouldn't know about the case, but if they sit there and read all the disclosure in the case and that is readily available, it's going to risk us being able to have a fair trial in this case. So again, we're asking for no contact through.
No, I'm not mentioning that today.
Well, I just went through those. So let me talk about some of the factors under ARS 13-3967B. The things that court can use in determining method of release or the amount of bail are the things that court should take into account. And I'm going to go through the ones that I feel are applicable to this case. One, the views of the victim. She has been subject to constant harassment and intimidation as a way to try to pressure her to not go forward with this case. And I do want to be very clear that Ms. Walker has not brought this case, that the state of Arizona is the one pursuing this prosecution. The state of Arizona is the one bringing this case. The victim, regardless of whether she wants to go forward with this case is absolutely going forward through the state of Arizona. The nature and circumstances of the offense, once again, we have repeated harassment regardless of court orders and in violation of court orders. And again, he's facing mandatory prison time. We have evidence the accused poses a danger to others in the community. Again, in this email, he decided to provide to me a list of people that he's been filming in the community. He gave me a list of that he has videos about, to include 7 federal judges, 13 local Pima County judges, 5 local prosecutors, 25 local members of law enforcement, 18 employees of the city of Tucson, 39 employees of Pima County, the FBI, 10 U.S. Marshals, 20 U of A employees, and 15 U of A police. So this is a list he provided to the state indicating the people he's been videoing. We have witnesses who are scared and intimidated, and people who do not want to come forward because of the fact that he's been targeting them, and they're concerned that they're going to be posted on the internet and have a lot of people coming after them. Like I said, he has targeted everybody involved in his criminal cases, including posting addresses of theirs online. And number 6 under 133967B is 6, weight of the evidence of the accused. The state has very strong evidence of all of his crimes in this case. He's been live streaming about them, so we have video evidence. We have his admissions. Just yesterday, he went on and went through every single charge, talking about what he did to commit those offenses. So the state has very strong evidence against him, and we also have the records from the court. And then as well, the accused record of arrests and convictions. As previously noted, he does have prior convictions, which makes him facing mandatory prison time, and he has a lengthy arrest history. And so, for all those reasons, we are asking for these more stringent release conditions, because I think it's necessary to protect the victim and others in the community and other people connected with this case. And then I also want to point out the Arizona Constitution 2.1, the Victim Bill of Rights. The victim is to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal process. And just from him getting a summons, he immediately targeted again the victim and immediately was calling upon third parties to engage in harassment, intimidation, and abuse towards this victim. And so these release conditions are necessary to protect the integrity of this case, to protect the integrity of this system, to allow people to maintain confidence in the judiciary system, and above all, to protect the safety of our victim. So thank you.
Mr. Parkin?
Yes, Your Honor. First of all these are available as a matter of right. No violence has been alleged. A lot of this may have some free speech issues. I realize there may be strong evidence perhaps of something, but there's been no convictions, and the state's alleging already class 5 felonies for prior convictions. There's also an appeal pending of that injunction, which it may not have been valid in the first place. That may be some of the contact because Mr. Myers, through the appellate process, has to serve Ms. Walker. I don't think Ms. Walker is represented in that case. I may be wrong. So he legally has to give her those documents for the appellate process. Also, YouTube, it's all over the place. We don't know who's posting. It's not just Mr. Myers here. Again, and also there's court camera. There's all sorts of things all over, both on shows, on TV. Again, I haven't heard anything about any violence or specific threats to safety. I know there are a lot of charges, but a lot of them are related. In fact, some may even have some double jeopardy concerns based on what happened in another court. That there's also, it should be special action proceeding, but that's a different issue. My suggestion is that release conditions sufficient to make everybody happy is release the pretrial service with a condition, at least, and this is not a violation of your First Amendment because you have a right to a speedy trial. Pending the outcome of this trial, keeping in mind your speedy trial rights.
I'll agree.
No blogs.
I'll agree.
No, take down all videos.
I'll take the videos that are listed down.
Everything, no communication. We can't control what other YouTubers do. But Mr. Myers can at least, to respect this court, the victims, and release conditions to alleviate concerns while this case is pending. Again, that's not a violation of your rights. It's an exchange for not being in custody.
I agree.
No internet at home, no YouTubing. You just stay in contact either with me as advisory counsel, if you represent yourself, or me as your attorney.
Yes, sir.
And that should alleviate any concerns, Your Honor. And if there's a violation of that, then we can come back and talk about it.
If it's as simple as like removing the videos that are continuing to be alleged as harm, take them down. Then once we figure out is it free speech or a crime, we'll deal with that later.
Let's solve your cases first.
Right, okay.
Your Honor, just that he has been ordered to have no contact and do these things before, and yet he has continued to do them. And like I said, as of yesterday and today, he's been continuing to go forward on harassing this victim.
He's never ordered not to make a video. I think that's a legal issue down the road, but that's why, to alleviate concerns, I think my recommendation, or our recommendation, is fair, Your Honor.
Thank you, everybody. So I am going to release Mr. Myers to the supervision of pretrial services. No contact of any kind with the victim or the victim's family. Do not go to the victim's residence or workplace or the victim's family's workplace. Take the videos down of the victim.
Specifically the ones that are alleged in the summons, right? Not all my videos that she read off, right?
Take everything down
All
in
right,
this case to be
Anything
safe.
related to the victim.
The victim. Okay.
Yep. All right.
Yep.
That's it for today then.
Thank you.
Everybody.
Thank you, Your Honor.
And Your Honor, can we also make sure that he's directed that he's not to have a third party do any of those as well?
No contact means not directing to somebody else, because what you're doing there is subjecting that third party to a crime. So if these are your friends, you don't want them to be convicted of a crime as well. So no third parties can contact the victim.
And Your Honor, would you please advise him of what could happen if he were to violate a condition of his release?
There could be a motion to modify, and your release
Can be taken into custody, all right? I think that's been clear.
could be revoked. All right, thank you, everybody.
Thank you, Your Honor.
Where do I go?
Hold on. I'll walk you to the second
Okay.
floor.
Okay.
All right? And I don't know if you can get it online.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.